starts in 3, 2, 1.
Засідання продовжується.
The session continues. Please invite to the session room the candidate for the position of a judge of the Hague, Yuriy Volodymyrovych Bodnaruk.
Розглядається питання щодо
We are considering the issue of compliance of the candidate for the position of the judge of the Hague, Bodnaruk Yuriy Volodymyrovych, with criteria Part 4, Article 8 of the Law of Ukraine High Anti-Corruption Court. Here at this room we have members of the PCI, Robert Heinbrook-Hayden, the chair of the PCI, Norman Aas, Mary Butler remotely, John Sullivan, Jessica Lund-Thompson remotely. Also, we have here members of the HQCJ, Михайло Баханіс, Віталій Гацелюк, Ярослав Дух, Роман Кедосюк, Ігор Кошнір, Руслан Мельник, Олексій Омельян, Роман Савадаш, Руслан Сидорович, Сергій Чумак, Галина Шевчук. Mr. College is absent today because of the official necessity. So, is the composition of the HQCJ PCI is clear for you? Yes. You have a right to submit recusals for the Commission members based on the legislation provisions, expressed concerns and challenge decisions as envisaged under legislation. I would like to pay attention that at the special joint meeting we do not consider any new materials submitted by a candidate if such an opportunity was granted to the candidate before, but the candidate or other persons failed to submit it to the PCI or Commission under relevant circumstances upon the initiative of the Commission, but with the initiative of the Commission of PCI, and there could be a decision made regarding attachment of the relevant documents if we have at least 3 votes of the PCI members. Do you have any recusals or for the Commission members or motions? No, I don't have any recusals or motions. I pay your attention to comply with rules envisaged by the rules of procedure of the HQCJ. The relevant information is printed out on the memo which is in front of you. Do you understand your rights and obligations? Yes, it's clear. The rapporteur is on the screen today is Mr. Melnik. Mr. Melnik, over to you. Thank you.
Bodnaruk Yuriy Volodymyrovych.
So, Yuriy Volodymyrovych Bodnaruk. In 2024, he graduated from the Odessa National Law Academy and received a full higher education in specialty jurisprudence and obtained the qualification of Master of Law. In 2008, Mr. Bodnaruk obtained the candidate of legal science degree at the Odessa National Law Academy, specializing in administrative law and procedure, financial law and information law. Based on the decision of the Station Board as of September 2012, Mr. Bodnaruk was awarded the title of Associate Professor of the Department of Administrative and Financial Law. Regarding professional activities, in 2005-2019, he carried out scientific activities, first as an assistant and later as an Associate Professor of the Department of Administrative and Financial Law at the National University. He also worked as a legal advisor at various companies. Since 2019, the candidate has been working as an assistant judge at the High Anti-Corruption Court. So, Mr. Bodnaruk has a degree in law and at least 7 years of experience in legal research and is fluent in the official language at the second level. It's also worth mentioning that Mr. Bodnaruk participated in the competition for vacant positions of judges of the High Anti-Corruption Court announced by the decision of the HQCJ as of November 23, 2023. And by joint decision of the Commission and the PCI dated February 17, 2025, he was found as non-compliant with the criteria set forth in Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court, and therefore his participation in the competition was terminated. It's also worth mentioning that Mr. Bodnaruk participates and the competition to the appellate courts of the general jurisdiction. De facto, he is right now in parallel into competition procedures. At this moment, that's all from my side. Thank you. Was everything rightly reflected? Do you have anything to add? No, thank you for your report. The information is reflected correctly. At the same time, maybe during my speech, I will also add some information regarding my participation in other competitions. Okay, thank you. The floor is given to the head of the PCIe, Mr. Robert Hein-Broekhuizen. Mr. Robert, over to you.
Thank you, Chair. Mr. Judge John O'Sullivan is your rapporteur this time. Thank you.
Good afternoon, Yuriy.
Your microphone, John.
Oh, I'm sorry. Good afternoon, Yuriy. Let me introduce the other members of the panel. Can the translator hear me okay? Yeah, okay. Beside me is Robert. Robert's a lawyer in the Netherlands, and he's the chairman of the PCIe. And next to him is Norman. Norman's a lawyer from Estonia. And then up on the TV screen to your left on the bottom is Mary Butler, who's a prosecutor with the Department of Justice in the United States. And next to her is Jessica, who is a lawyer from Canada. And my name, of course, is John O'Sullivan. I'm a retired judge from the United States. I had the opportunity last time we met about a year ago to speak to you about your qualifications then. I know that since then, you were found non-compliant for the position of the judge of Hack, and you appealed that decision to the Supreme Court. And the Supreme Court didn't rule on it substantively, but rather dismissed your appeal or denied your appeal. And my understanding is that you've now appealed that to the Grand Chamber of the Supreme Court. Is that correct?
Yes, indeed, it's true. Right now, the appeal procedure is happening. The consideration on this written proceeding has been assigned. Shall I add anything?
No, well, I saw in your papers, in your response to some of our questions, that you indicated that the appeal hearing was scheduled for today, February 26th. Is it still scheduled for today?
Indeed, it's true. I have not received any information regarding any other dates, but yes, indeed, it's coincident that, you know, the consideration in a written proceeding is assigned for today, so without summoning the parties to come to the court.
Oh, I see. Okay. Do you have a lawyer who represents you in that matter, or are you representing yourself?
I do it by myself. I have presented myself. I don't have any lawyer. In the cassation administrative court, as a court of first instance, I presented myself. I didn't have any other representative.
Okay. Anyway, we sent you some questions, and you've provided some detailed information. And the predominant question was if there's any new information and evidence related to our prior decision. In other words, why should we not just continue in our prior decision? And you provided detailed answers indicating where you thought that our calculations of your finances were incorrect. Does that sound about right to you?
Yes, indeed, that's true. In my replies to your written questions of the PCIe, I provided copies of the statement of motion, of the appeal claim. I provided a brief justification of the decision regarding this claim, from which I submitted to the cassation court, and I also provided you with key reasons reasoning, with key grounds of my understanding, my conclusion, why I think that in that decision there were certain methodological inaccuracies, which actually led to underestimation of my real income. And I also provided documentary evidence, which I managed to collect during this year. And I also provided some new grounds, new arguments, and new facts, which are newly identified. They had not been discussed at that interview, at that session. And when we reach out this point, I would like to explain those details to you. And I want to try to convince to you. Unfortunately, I failed to convince you last time, but I want to try this opportunity today to try to convince you and for you to be sure that I comply with the requirements for the Hague judges.
Well, I'm going to ask you some detailed questions. And then if in the end you think that there's something else you should add, if we have time, you'll be permitted to do that, okay? So we had basically two calculations, as I recall, and I think you agree. One was your spendings during the years 2004 to 2016. That's the first one that I'd like to address with you. So we had come to a conclusion that you had available to you after your expenses, looking at your income and your expenses, approximately $145 a month to spend during those years. And you've taken a look at what our calculations were, and you've made some corrections to them. You believe that rather than 13 years, we should only consider 11 years because until you were age 23, your parents had an obligation to support you because you were a student. Is that correct?
It corresponds to the provisions of the family code that parents, if they can do it, and indeed they manage to do it, so they keep maintaining children upon the age, this age, if they study. And I studied at the university, in campus studies, or postgraduate studies, and indeed the whole sum should have been divided by 11 years, not 13 years. But it was not only my concern regarding those calculations. No, I had also some other concerns. And if I may, I can add those.
Well, I'm going to mention some, and then if you think there's any others, then you can explain that to us. Well, let me ask you, during those first 2 years, when you contend that your parents were obligated to support you, you still spent some of your own funds during that time, didn't you, in supporting yourself?
Maybe yes, it's hard to differentiate, but during those first years specifically, and I mentioned already that starting 2004 to 2012, actually the support from my parents was significant. And afterwards, when I started earning more, I didn't require support of my parents. I already was saving some money, and I was capable to support them in return if there was such need. And the support, financial support from my parents, which I had got from them, it was helpful for me, and it gave me an opportunity to save certain amounts of money in order to purchase an apartment in future, which was under question.
So going back to this calculation for 2004 to 2016, you also took issue with the fact that we used a calculation to determine the approximate amount of taxes, and we applied that to all of your earnings, and some of your earnings would not have been taxable. I'm not sure exactly, but like contributions to Social Security, some funds that you may have received from the school. And so you recalculated that, and you found that under your calculation that you would have had an additional 4,261 hryvnias, or $602 available to you during that time. Is that correct? I'm talking about your calculation, not mine.
Ні, не зовсім розумію про 40 тисяч гривень.
No, I'm not sure that I understand this information regarding 40,000 hryvnia. That's why I would like to provide you explanation. Yes, indeed, that you are rightly saying that there were certain.
It wasn't 40,000, it was 4,261 hryvnia, or $602.
Хочу пояснити
I
стосовно
would like to
цієї
explain regarding these figures. It's not the whole amount of underestimation. No, that's only related to the new circumstances or facts which I identified, which I studied this issue of my income. These are new facts, and I checked the accurate tax which the tax agents accrued for me, and I realized that for 2 years, 2008 and 2013, the data which is included in the tax database has a higher level of income than in comparison with the information which exists in the state register of individual taxpayers. So I cannot provide why actually such discrepancy exists between these two different registers. But yes, indeed, it's in my benefit in the total amount of $600 dollars for 2 years. But that's not the general amount of underestimation of your calculations, which I arrived as a conclusion when I analyzed your table.
I understand. That's one part of what would change the numbers, and it's your words. It says the decision underestimates my actual income for the period under review by UAH 4,261, equivalent to USD 602. Right? That's what you indicated. So you also then made a calculation after making some other adjustments where you indicated that you actually had approximately $236 a month available to you for the 11 years which didn't include the 2 years that your parents were obligated to support you. You agree with that? $236 a month?
Так, я надав цю
Yeah, I
інформацію.
provided this information. Indeed, this information was based on the following, that at your previous decision, in any amount, you took into account financial support from my parents. Also, I mentioned this financial support from my parents. So I made some corrections of my income. I added conditional, $50 of such potential support, and I received, yes, something like this, around $240. That's what I had each month as a free amount of money to spend on some daily expenses, and it's also part of savings which I used for vehicle and apartment, which you motivated as your negative decision in the last year. So if we take the subsistence minimum for living, which was mentioned by the PCIe, and I generally accept this fact that for this last 11 years, for those 11 years, it was on the level of 110 USD. So it means that I had around 2.5 subsistence minimums per month for my daily and routine expenses. And I also would like to add.
I actually don't want you to add anything because I asked you a simple question. Did you tell me, which I'll read to you, we get 236 to 237 per month? That's your number, correct? That's what you indicate our number should have been. Rather than being 140 something, it should have been 236 or $237 a month available to you. You confirm that, correct?
Так.
Yes, I confirm that were available for me a part of those funds that were allocated specifically to save money in order to purchase apartment and vehicle. So these funds were exclusively for my routine expenses.
Okay.
Recording in progress.
Cents US dollars a day. Do you agree with that?
Я не ділив на день, я визначав, скільки приблизно на місяць. Ну, я Довіряю вашому розрахунку, мабуть, так і є. Я не маю зараз змоги перевірити.
Yeah. So, I mean, if it was 240, you can divide that easily by 30, right? That's $8 and it's a little bit less, 236, so $7.86 a day. Yeah. And you were living in a big city at that time in Odessa, correct?
Так.
And do you agree with me that $236 a month or $7.86 a day is not a very, very much money for a young man to live in a big city like Odessa?
Це не досить велика сума, але цієї суми мені вистачало з огляду на те, що я є неодруженим, я не маю дітей і не мав дітей, і не мав кого утримувати. Більшу частину цього періоду, який ми досліджуємо, я проживав фактично безкоштовно, або в гуртожитку тривалий час проживав, або в квартирі батьків з десь 2010 чи 2011 року. Тобто не витрачав коштів на оренду житла і, відповідно, вів скромний спосіб життя, я не мандрував по якимось курортам і не здійснював жодних дороговартісних придбань. Нічого, немає жодних і не може бути жодних об'єктивних відомостей про те, що я якось не економно витрачав свої кошти. Чи вів розкішний спосіб життя.
And you also claim that you received material support from your parents from the age of 22 in approximately 2004 until you reached 30 years of age in 2012. Is that correct?
З 24-го, може, з 2004-го, можливо, переклад некоректний. Повторіть, будь ласка, ще раз, бо, мабуть, некоректний переклад.
2004 to 2012.
Так, з 2004 по 2012 рік, так.
And then at 2012, your salary was increased for the next 3 years, 2012, 13, and 14. You earned in total approximately $30,000. Is that correct?
Так, я так про це і зазначав, да.
And if you divide that 30,000 by 36 months, that's $833 a month. And you've indicated that a lot of that money you gave to your parents.
Так.
And at that time, you were saving money in dollars?
Так, я декларував в декларації, яку подавав у зв'язку з прагненням взяти участь у конкурсі на посаду судді Верховного суду. І в мене станом на момент було
Okay.
Відновлена трансляція, прошу продовжувати.
мені відповідати, чи ви продовжите питання. Я перепрошую. Я декларував за 2015 рік залишки заощаджень своїх власних у сумі $20,000 та 50 тисяч гривень готівкою.
So during that time, 2000, 14, 15, and 16, you were finally making a nice salary and you decided to give most of that to your parents. Is that correct?
Так, я пояснював
Yes,
раніше.
I was explaining previously why I had this motivation. I can repeat them if necessary.
And you, in your response to our questions, you indicated that you're unable to provide evidence of the financial support that your parents had given to you prior to that time because bank statements are no longer available. The Postal Service doesn't have records that date back that far that would show delivery of packages from your parents to you. And other records from your school are unavailable. Is that right?
Так, але окрім того,
Yes, but besides, the main argument regarding that is that this support was mostly provided in kind, that is, in the form of clothes, food. Back then, by the way, it was very prevalent network of Nova Poshta, and my parents continued sending me these parcels by bus to a student then, or when I was coming to visit them. They were giving me respective food products, clothes, or cash funds. And by the way, they still, as of today, do not use bank transfers in the form of initiation. They get salary or pension to their card accounts, and they are unable. They never initiate bank transfers still. They withdraw these funds, and then they are spending that money in cash in view of their age.
So you indicated that you had attempted to get bank statements, but if you had gotten bank statements, it wouldn't have assisted you in being able to demonstrate that your parents had provided you substantial money until the year 2000 and until the year 2012, correct?
Саме так. Я хотів, намагався отримувати.
I tried to check. Maybe there were some transfers. Maybe someone helped them through bank offices, but actually, I do not remember these facts. And moreover, back then, the salary project of the university was serviced by Imex Bank that was liquidated in 2015. But in any case, the main argument is that this support was mostly in kind from my parents in the majority of instances, or in the form of cash.
Okay. So you have no evidence to support that other than your own word and the word of your parents, correct?
Не зовсім правильно.
Not correct.
Минулого разу на
Last time, during the previous
спільне засідання, я надав
special joint meeting, I provided written explanations from my mother. I was attaching them to written requests from the PCIe about the circumstances that she actually confirmed the provision of this support. It was not reflected in the written decision. I don't know why you did not pay attention to that. Moreover, in the materials of my dossier, there is information in the form of experts from the registers that my mother was engaged in entrepreneurial activities from 2003 to 2011, and accordingly, she had an opportunity to additionally she had income that allowed her to provide the support to me. These documents are available in the dossier. Besides, since it was mentioned that I allegedly did not provide any written confirmations in your previous decision, I additionally addressed my parents And we concluded with them a simple written agreement for because the civil code allows to conclude agreements not for the future but also for the past. And through their signatures, they confirm the fact that some of the money that they had back then were provided to me in 2016, so that I had a chance to pay the second installment to the cooperative.
And that was money that they were returning, that you had previously given to them, that they didn't spend, and now they were giving it back to you. And you had given them that money in US dollars. They returned it to you in US dollars.
Я не можу згадати, в якій
I cannot recall in which form it was, either in dollars or no, when they returned this money to me. The matter is that when it was necessary to pay the second installment, it was paid in the national currency through the bank transfer. And it was necessary to convert these savings into hryvnias. We, together with my father, went to the bank and made this currency exchange transaction. So I cannot say at which point they gifted it to me, either in dollars or once we converted and then they gave this money to me.
So if it was in dollars, any agreement is supposed to be notarized. Is that correct? If it's in any foreign currency other than Ukraine?
Якщо стосується валютних цінностей,
If that's about foreign currency, yes. At the same time, I would like to say that back then, we did not conclude any agreement. In 2016, since this was a relationship between me and my parents, we have full trust among us. There was no need to conclude such kind of an agreement with a notarized certification, because no one planned to challenge that in court, to recognize it as invalid or to submit any demands. And I would like to point out that this apartment that we are talking about right now, after its purchase, and once my parents gave me a pot of money, starting from 2019, it's being used by my parents. They live there. I do not live there because I live in Kyiv. So they returned my savings to me, and now they live in the same apartment. That's just to demonstrate our relationship of mutual support.
And the agreement that you provided to us was actually made in April of 2025. That the agreement that reflects the 30,000 US dollars that your parents returned to you or gave to you as a gift, correct?
Саме так. Це я попросив їх підписати.
I asked them to sign this agreement. They agreed to do that. They agreed with the content of it in order to confirm for you this fact that I'm not misleading you about this situation. And with their signatures, they confirmed that this situation really happened like it happened. And actually, these were also written explanations from my mother that I provided last year.
Okay, and the last time we met, there was a second calculation that we went through during the hearing and was reflected in the opinion, in our opinion, which discussed how much money you had access to and how much money you spent in the year 2019, correct?
Так, саме так.
Yes. Yes, correct. That's the matter of the discipline of declaration for 2019, and it became the second ground for the reasonable doubt that was described in the joint decision.
So I want to discuss that with you. I want you to be concise in your answers. In fact, I'm going to ask you a few yes and no questions, which I'd appreciate if you would answer in that fashion, and then I'll ask you for some explanations. But the items that you brought up was that we incorrectly established the circumstances regarding the funds you spent for car repairs that we indicated that you had spent in 2019. Your argument is that approximately 130,000 hryvnias were spent in 2020. The second item you brought up was that you had small loans that were given to you that you weren't required to declare and that we didn't consider. The third was that you had purchased a tour for Egypt for travel in 2020, and that we had considered that perhaps you had paid that in 2019. And the last thing is that you received $5,000 from your sale of a Chevy and Vonda car in 2019 that we didn't take into consideration in showing the flow of funds. So let's first talk about the tour to Egypt. According to NABU, you visited Egypt twice, once on January 22nd, 2019, for 8 days until January 30th of 2019. And then a second time on February 15, 2020, until February 22nd, 2020. And you provided documents to us recently to prove that the 2020 trip was paid for in right before the trip in January or February of 2020. And therefore, it should not have been used in making the calculation regarding 2019. When did you pay for the 2019 trip that occurred in January of 2019?
Та поїздка, яка відбулася
That trip that took place in 2019 was paid in 2019, and the trip that took place in 2020 was paid in 2020.
Okay. And by the way, none of those expenses went into the calculation that was shown in our decision or shown here in court. It was mentioned in context that there was also a trip to Egypt, or two trips to Egypt, 2019, 2020. You've now provided us documents that reflect how much money was spent in 2020, but you haven't provided us documents with how much was spent in 2019, have you?
Копію туристичного договору.
The copy of the touristic agreement was not provided by me because I did not refer to that in my claim. At the same time, I would like to point out that you might have access to that copy of the agreement because it is available in the materials of my dossier during the participation for competition to the HQCJ, which is stored by the HCJ, and the HQCJ, according to the dossier, got access to that dossier. So that agreement is there because immediately, along with the documents for participation in the competition for the position of the member of the HQCJ, I sent all the documents, including these touristic agreements. They are available in that dossier. So I do not see the need to duplicate and to resend that.
Okay. So let's talk about the car that you purchased. You purchased the car in 2019 from you had a friend assist you and purchase the car in 2019, where you paid 126,000 hryvnia for the car that was not in good shape. It had needed a large amount of repairs, correct?
Саме так, цей автомобіль
That car was after a traffic accident. It had significant damages. The value of the lot at the auction in the US was $3,500, and I declared that as the price of the car in the equivalent. That was about 96,000 hryvnias. But in order to provide more accurate information in the declaration, I also added general expenses, which included, apart from the value of the lot, the fee of this platform, as well as supporting expenses on transportation and customs clearance. and the total amount was approximately 126,000 hryvnias.
Okay, and after you got delivery of the car, your friend Mr. Pozar proceeded to repair the car, and in fact was able to receive a certificate of conformity to register it in December of that year, correct?
Саме так.
Yes.
Автомобіль був поставлений.
The car was registered on the 26th of December of 2019,
безпосередньо
with immediately before the New Year holidays. And in written communication, I provided additional explanations in writing from my friend and my own explanations with the specification of the motivation as to why it happened before the New Year. If necessary, I can repeat.
No, I'm familiar with that, and the rest of the panel is familiar with your responses. But Mr. Prozar and you indicate that even though he did some of these repairs in 2019, he didn't receive payment from you for all of it until all the repairs were completed in 2020. Is that correct?
Саме так. Я про це і зазначав. Це відповідає дійсності.
Exactly so.
Остаточні роботи були
had indicated that
на початку 2020 року.
Works were finalized in late 2020. We did the calculations and the rest of the amount because I made an had made an advance payment before, and I had also purchased some materials on my own, and I also provided that. There was still the remaining amount that must have been paid by me. So by the end of 2020, I paid off the debt.
130,000 hryvnia, correct? Approximately.
Ні, дивіться, 130
Not
тисяч
exactly.
гривень – це сума,
130,000 hryvnia is the all amount, the whole amount. Part of that sum, lesser amount, was spent in 2019. For example, I bought radiator brush myself, and then I also made an advance payment, another small part, for him to be able to order something, to pay for goods and services that he needed to be done for this repairs. And in 2020, I paid off the remaining sum after we did the calculations.
Didn't Mr. Prozar indicate that he did all the repairs with his own money and you paid him back in 2020?
Але не 130 тисяч
In
гривень.
2020, but I paid a lesser amount because 130,000 is the whole amount. Lesser amount was spent in 2019, and the bigger amount was spent in 2020. And it's up to him how he used that money, but I paid him like this. And I paid him less than 130,000 in 2020 because we had already spent part of it in 2019, in the fall of 2019. In my answer to your question, I indicated that he turned to the where some proofs.
Can the interpreter hear us?
1-1 testing. Yes.
Okay, I can hear good now. In fact, in your statement to us, you said.
Переклад, можливо, перерва необхідна.
Do we need a
Для
break
відновлення перекладу.
No, we're good.
in order to resume interpretation?
Ні, Вибачаюся, переклад продовжуємо. Продовжуємо.
Okay.
So we shall continue.
In your statement to us, in response to questions, you said there was no reason to include UAH 130,000 for car repairs in my expense for 2019. That's your words, correct?
Так, не було підстави, так, це моя позиція.
Yes, there were no, these are my words, and no, there were no grounds. And it was a friend of mine who did the repairs.
Okay. You also indicated in your response that we ignored your explanation regarding small loans that you received in that year. Do you have any documentary evidence to support your claim that you had such loans?
Мається на увазі.
What I meant was, I'd like to explain it again. I did not get a loan in the proper sense of this word. What I meant was that debt that I had, my friend's spendings in my interests that created grounds for me to compensate those spendings to him in the future. And I hold it alone because thing for me. Him, and I needed to compensate it. He made me a favor,
On the car.
and I needed to
In
compensate it.
October of 2019, you transferred that car to Mr. Yakubenko. Is that correct? Or Mr. Yuriy Vasilovich Yakubenko?
Так, саме так.
Exactly so.
Okay.
Так.
And you received approximately $5,000 for that car, correct?
Yes,
Саме так.
And that was on October
Exactly.
16, 2019?
Так, це було саме 16
Yes.
жовтня, я запам'ятав, бо це
October 16, 2019. And I remember this day because it was my birthday,
Цей правочин здійснив.
Okay.
and we made
you
this
did
deal the
not-
day.
You did not reflect that income from the sale of the car on your 2020 tax return. Is that correct? Or on your declaration?
Не відобразив у декларації 2020
I did
року,
not
тому що
reflect
я
it in my
не подавав
declaration
декларацію за
of
2020
2020
рік,
because
і
I did
не
not
зобов'язаний
submit it,
її подавати.
and I was not obliged to submit it.
Я мав такий обов'язок, я би відобразив цю
I
суму доходу.
I had been obliged, I would have reflected it in my declaration as of 2020.
I actually misspoke. You received the money in 2019 and you didn't reflect it in your tax return of 2019 or your declaration of 2019. Is that correct?
Так, я не відобразив декларації в 2019
correct.
році.
I did not reflect it in my declaration of 2019 because
такими міркуваннями, які відповідають
I was guided by the thoughts according to the NAZK recommendations. We did not conclude a purchase agreement, and therefore that deal did not prove the transfer of property, and therefore I didn't have legal grounds to reflect where I got that income from. So I could reflect it in the declaration 2020 as soon as the buyers register the car in their name. But in 2019, I submitted my declaration as assistant judge, and in 2020, that obligation was cancelled in the legislation. I was not obliged to do it any longer.
Well, just to be clear, you received $5,000 in 2019. That should have been reported on your tax return in 2019. regardless of whether or not this gentleman decided to register the car. If he had never registered the car, would you never have to report the income then?
Те роз'яснення НАЗК, яке я знайшов з
So
цього
the National
приводу,
Anti-Corruption Agency's explanation that I found on the subject says that authorization is not a proof of the transfer of property, and owners and the virtual owners need to declare the amount of the car. And as to the period when the income must be declared, I didn't find such explanations, right?
НАЗК з цього приводу, які би прямо вказували на те, що я цей дохід.
So I didn't find any anti-corruption agency recommendation as to my obligation to declare the income from the sale of a car in my declaration of that same year. You may be aware of other guidance, but I was guided by what I had found at that moment.
Okay, I have no further questions at this time. Thanks.
Thank you, John. Norman, question? Jessica, question? No? Mary? Then back to you.
Wait, I do have one question.
Oh, yeah, sorry.
I'm sorry if other people understand the nature of your position, but could you explain to me what your duties are in your current position at the High Anti-Corruption Court?
Які мої обов'язки на поточній посаді ВАКС? Я працюю
So what my duties are in the HAC. Since 2019 until present, I have been assistant judge of the appellate chamber of the HAC. And among my duties are facilitating administration of justice by the judge as a member of a group in cases where he is.
I don't understand what that means. I don't understand what that means. Do you help write opinions? Do you do legal research? What do you do?
Так, я про це і розповідав, просто
Yeah, I was telling about that, and then technical break happened.
I'm sorry.
So I do the selection of relevant relevant laws and bylaws that must be referred in disputes. I analyze the materials of the case files. I analyze appellate claims, appeals, and the most responsible part of my work, most complex one that assistant judges have, is drafting court decisions in cases. So this is the most complex element of my work for all the cases considered by the appellate chamber. And beyond that, working with Judge Mikhailenko, I also have interesting assignments when some judicial practice is not straightforward. he tries to
в межах доручень отриманих сформувати
handle it,
позиції,
resolve it,
дозволять,
understand it better,
зробити
and I help him to do so in order to make judicial practice
верховенства права,
more easily predictable, to make sure the parties are able to adjust their conduct and for them to have an easier time forecasting a court's decision in a certain case. And many court decisions that affected the progress of judicial practice have been dealt with my participation, and I'm proud of it. Thank you.
And are you assigned only to a particular judge? Do you do this work for other judges?
Саме так, це посада помічника
Exactly
судді,
so.
це патронатна
So,
служба і
assistant judge
працюю і сприяю
works within
працюю в офісі одного судді саме.
one service under the auspices of one judge.
And one more question. I see that before you became an associate professor, you worked at a law firm called S&S Legal Consulting in Odessa. And can you tell us how many lawyers worked in this firm?
Чесно кажучи, я не можу сказати, скільки саме правників.
Honestly, I don't remember how many lawyers worked there because many years have passed since then, and I informed you earlier that that firm was founded through reorganization of one of enterprises, one of the a group of companies in Odessa, and employees of one of the companies moved to this law firm after it was rebranded, and one of the attorneys was a leader in that firm, but I don't remember the exact number of lawyers there.
Less than 10, do you think?
Я думаю, що менше 10.
I think less than 10.
And in your work at the S&S Legal Consulting, did you handle any corruption matters? Corruption cases or investigations?
Щодо розслідування справ корупції не стикався. Ну, в якому плані?
With investigations of corruption cases, no. Well, at the earlier stages, I didn't have attorney's license, and I was not able to consider criminal cases. But when the director, the only attorney, moved to a different position, there was a need to have an attorney in this firm in order to offer defense to clients. And to do so, I sat the exam, the bar exam, and got my license. And the first case that I got from the previous attorney was about a corruption offense. There were two suspects, one of them an architect, the other village mayor, and they got a bribe in order to grant a big land plot in one of the districts of the city, and it was on the seashore, land plot on the seashore, and that was a very useful case and interesting case, and it was about a corruption case.
And so that was your experience as a defense lawyer handling corruption matters. Is that right?
Yes, indeed. It was a criminal corruption offense. At that moment, it was called corruption offense.
No further questions. Thank you.
Jessica, questions? Norman? No? Back to you, Chair.
Thank you. Dear colleagues, do you have any questions to the candidates? And the rapporteur has some questions. Please, over to you. Thank you. So, the Public Council of International Experts has had a detailed interview with you, and I would like to have a more generalized approach to the covered issues and to mention that the specifics of today's interview is the following, that Yuriy Volodymyrovych, in comparison with other candidates, you are somehow lucky, somehow maybe not lucky. Why you were lucky? Because you had more time than any other candidate to prepare yourself to the interview, because you specifically understood what this interview will be dedicated to. And you indeed prepared yourself to this interview. Your explanations are quite detailed, structurized, and we can observe very clearly that you approached this problem in the following manner. You took main concerns indicated by the PCIe and HQCJ during our previous interview. You divided them into two general parts. That's regarding reasonable doubt regarding source of funds to purchase apartment in Odessa, and the second part, that's reasonable doubt regarding your income and available funds for your daily life during certain years. So we have heard today your comments for both parts of concerns and reasonable doubts, but we would like to underline that the following. So you understood completely the situation with what the Commission considered as not enough during the previous time. So you should have tried to add some documents to prove and to convince Commission to change the opinion. So as a follow-up question, let's go section by section. Section 1 and then section 2 of the negative decision of the previous one. A part of information which definitely overlaps with the whole volume of information which was already provided, analyzed, and processed before. But what about documents? How do you have any documents that you can accompany your position with, and can you strengthen your grounds, your arguments? Do you have anything to add in order to maybe to change a little bit our position and to stand on your side? Thank you so much. I have already referred partially to those documents, but please give a general answer. Yeah, so regarding the sources of income to purchase an apartment in Odessa by me, I have already provided, as it was already mentioned, I have provided in the written form an agreement on the transfer of this sum to me between me and my parents, according to the Article 331 of the Civil Code of Ukraine, and this regarding the fact of transfer of these funds before. So, as I have, sorry, Yuriy Volodymyrovych, just about documents, nothing else. No, I just wanted to explain why I actually reached out to a specific organization. So the organization which provides maintenance services to my building where I live. So I reached out to them regarding certain issues of change of property status from non-residential to residential. So I received as a reply documents from them, engineering documents and development documents regarding the property which I purchased. It was designed from the very beginning as it should have been designed, and everything took place according to provision of legislation. And I also reached out to the university regarding the questions that I received regarding the expenditures which I had during my residence in the dorm of the university. So I was in touch with the university. They replied that unfortunately they do not keep such documentation, not only regarding specific payments, but even in general they cannot even provide identification of a sum that was identified for me to pay for the dorm residence. I provided also bank receipts during those years, and I provided screenshots of an account in my electronic account at the tax authorities, from which you can get understanding that for 2 years, 2008 and 2013, my income was underestimated. And I also provided PCIe with documents related to ending of construction of the house and commissioning of the house. And there was also additional reply from the maintenance organization that this declaration was never cancelled in administrative or any other judicial proceeding. And there was also information present that other neighbors who also had under their property non-residential premises, major part of them, 5 out of 6 neighbors who lived, who were on the same floor, they also changed the status of the property from non-residential to residential. And such applications to transfer property status from non-residential to residential, it's a normal procedure which is, you can apply submit such application on the electronic government website to change the status of the property. Sorry. I would like to clarify, these are those documents which had not been provided to the Commission during the first time. Yes. So you're trying to strengthen your own position and give new grounds in order for us to make new conclusions which you would like to get as a result of this interview. Regarding the second part, reasonable doubt regarding discrepancy between the lifestyle and income that candidate had during certain years. Yeah, so the first thing that I mentioned, so I reached out to my friend. He provided detailed written explanations regarding that, the following, that the final payments to him were based upon the repairing works, that why we registered the car just at the eve of Christmas holidays, why the final payments were done in 2020. He had also added some explanations, and he accompanied it with invoices and screenshots of how he had received those invoices via his email. And those invoices actually prove that he bought certain important spare parts for my vehicle. It was at the end of November 2019. A part of it I had also provided the agreement for 2020, and I had also provided documents which confirms de facto I sold the Chevrolet Levanda vehicle through the procedure of issue of power of attorney as of 16th October 2019, and I confirmed it with a printed document of the electronic account on the website Autoria. Autoria is a website where cars could be sold or bought. So there is a mark there where on 1st December I marked this announcement about selling of this vehicle as done, as the one that is already sold. So it means that also we have the data registration register of powers of attorneys. And this register also includes this power of attorney. I even attached a screenshot of correspondence with the buyer, where that buyer twice, where I asked that buyer twice whether they have already registered that vehicle on their name, because I needed to find out this information in order to fill in relevant information in my declarations. But they had some problems, and due to the pandemic, they didn't do it in proper time or as I expected. Okay, thank you. Considering the just mentioned list of documents and information that you provided to prove your grounds, this list of documents is significantly different in comparison with the documents that were provided last time. And you have provided us with documents in order to give more information regarding station where we had some doubts in the past. Regarding this part, I don't have questions. I just wanted to generalize, to have a general picture in order for us to have understanding why today's interview shall be different from previous one. And the next question. Actually, I'm having it as a result, as a consequence of the questions from the PCIe member. The report.
Прошу повторити.
Please repeat again in Ukrainian. Yes, of course, I will repeat. So, do we have interpretation right now? Yeah, you can hear us. Okay. So, as I don't know what our English-speaking members heard, what not. I will repeat my question completely. My question was related to the following, that as far as I've got from the questions of the PCIe member who was a rapporteur on your case, you didn't manage to share your position regarding the transaction which you called as alienation of property back in 2019, and the transaction as a result of which you shall declare the very fact of alienation. These are a little bit different transactions. What happened in 2019? That's issuing of power of attorney for alienation of property. Isn't right? Yes. Yes, that's right. And indeed, according to the NACP explanations which you refer to, if anyone receives a power of attorney for alienation of property, it's not a fact which confirms the very fact of alienation of property. So it means the fact of issuing of a power of attorney doesn't lead to the duty to declare such alienation of property. But at the same time, you say that as a result of giving such power of attorney, the transaction of sell and purchase happened. Does it correspond to the legislation provision? No, no, no. De facto, selling happened, but de jure selling of that property didn't happen. So let's be more concise, more accurate in our replies. So for our PCIe members have full understanding regarding de jure and de facto transactions. So we have transaction of selling and purchase of property. When it happened? 2020. Yes, in 2020. And in 2020, this transaction should have been declared. Yes, I thought it like this. So you, in return, you issued the power of attorney for alienation of that property. In such a way, you transferred this right for alienation of that property to another person for ownership and usage. And with the vehicle and with the power of attorney, I gave it to that person. And for this, you received relevant money. Yes. Yes. So, in connection, in view of it, the method that you opted for doesn't lead to such legal uncertainty regarding the date of declaring of such property. Here you refer to the NACP explanations. It's absolutely relevant because indeed the NACP explanations interconnect such transactions with the moment, the actual fact of alienation, rather than with the fact of issue of proper attorney. Sorry, if you need, I can explain why I opted for such method rather than for any other methods of alienation of property. Yeah, okay, please explain. So the issue is that we planned to document such transaction in a proper manner. So we reached out to the registration center of vehicles, which is located not far away from Odessa. We carried out an expertise assessment, and unfortunately, there was such practice, not diligent practice, and not proper practice, which was actually active before the reform. So the technical problems started in the system, in the electronic system, and that's what happened with us. So we tried to register that vehicle, but the technical problems in the system started. We didn't know when, how much time shall we wait, when it will be corrected, so on. We decided to return back later, and it was my birthday day. I didn't have time. I didn't know how long it would last, and de facto we needed to choose such method of alienation of property. Okay, thank you. And last question regarding the circumstances that we have already discussed before. We are discussing them and considering them on at the second round. You are providing us with new information, new evidence is always clear. The Commission will think about its position regarding this matter. But tell me, since that very moment of our previous interview, were there any other circumstances which could cause reasonable doubts from our side regarding your integrity? Have anything happened during this period of time which could cause reasonable doubts from the Commission? Thank you. I have received similar question in the written form from the PCIe, and I mentioned that at the beginning of 2025, it was 31st of January 25, if I'm not mistaken, there was, so I was ticketed for violation of parking rules. It was near my place of work. I didn't agree with that protocol of ticketing me. I didn't see the full text of it. I wanted to challenge it, but at the end of the day, so I received the text of the protocol only when there was already enforcement proceeding and my banking accounts were blocked. So I challenged it finally, and the court of first instance confirmed my conclusions, and the appellate court confirmed my conclusions. And yes, that ruling, that protocol was cancelled. Okay, thank you. So another question. Did you carry out any transactions? Did you give money to anyone? Did you take money from anyone as a loan or as a debt? Were there any changes in your lifestyle which could cause any doubts with Commission? No significant transactions were done by me, nothing. No, the only thing that I changed the vehicle. So, and it was discussed at the previous interview. Afterwards, there were no expensive purchases. I didn't leave territory of Ukraine from the moment of end of 2021. So my lifestyle has not changed. Okay, thank you. I have no other questions. Thank you. Thank you, Ruslan Ivanovich. Do we have any other questions? Hello. So last time there was long discussion and question to you regarding the apartment, and the city council allocated a land plot, and we were talking regarding permit documents and regarding the number of floors in that building. Yeah, I looked. There were 13 floor building. No, it was mentioned only regarding the number of floors in that building. It didn't mention residential, non-residential. So what are you talking about? No, I'm talking about the building, the apartment which you took under your ownership. We had a discussion last time. I looked at documents, I looked at the declaration on readiness of that premises, and there were mentioned 12 residential floors plus additional integrated and non-integrated non-residential premises. Let's go back to that agreement. So the gift date, if I'm not mistaken, the gift date was about what and at what amount?
Договір дарування коштів.
The date of gift regarding funds,
Визначили, оскільки ми не могли,
we decided that since we could not
мали можливість визначити
determine, we could not determine the specific amount that was remaining back then. So in our agreement, we mentioned
750 тисяч гривень.
750,000 hryvnias.
Скажіть, будь ласка,
Okay, understood. Tell me,
ці
please, then.
відносини
This relationship emerged and terminated when?
в 2016 році.
In 2016.
А договір ви коли уклали?
And when did you conclude this agreement? In 2025.
На вашу думку, договір може?
In your opinion, can the agreement regulate legal relationships? Because the agreement is a regulator of civil legal relationship. Can it regulate relationship that terminated long before its conclusion? I believe that yes. What is an agreement? Remind me, please, the definition of this notion. Agreement as a legal transaction on the basis of which mutual rights and obligations of the parties emerge. Which legal relationship was it regulating in 2025? It did not regulate anything in 2025. That was just a confirmation of the legal relationship that existed in 2016 in order to confirm my words regarding this situation. Why did you choose this particular way? I will explain why I chose this map. This question was asked to me by the High Council of Justice within the framework of the competition for the position of the member of the HQCJ. Back then, I said that we did not conclude any receipts. That's what we are talking. Since there was no need to do that, we were not going to go to court. We had no claims or demands, and that was just an ordinary transaction between parents and their son. And that's why I could not. I was not going to bring some written confirmation that is dated retrospectively. That's why I found the only possible way, in my opinion, using references to this provision of the Civil Code. And actually, I confirm that's a fact. Did you study the case law of the Supreme Court regarding their attitude towards that? I will quote it to you now. That's the position of the Cassation Commercial Court that is based on the legal position of the Supreme Court in another case. Indeed, under Part 3 of Article 361, the parties can stipulate that there had been legal relationship. At the same time, this provision of the law does not allow the parties to use retrospective action, which changes regulated and already full performed contractual relationship. The same legal position is stipulated in the ruling of the Supreme Court under case 110. As we've established your legal relationship and emerged and terminated in 2016, so no agreement concluded in 2025 can regulate the relationship that emerged and terminated before its conclusion. What is your position about that? My position is the following. This agreement, again, I will repeat myself, that agreement was concluded in order to provide at least any additional written confirmation of those facts that I mentioned previously. During the last special joint meeting, I provided written explanations of my mother to questions of the PCAE member. Basically, this agreement is an additional confirmation to confirm written explanations of my mother. That's why I'm asking that. There are written explanations from your parents. Why? Let me finish my question, please. Why? Why have you created a document that has controversial legal nature will use this careful wording. Instead of existing explanations, what's added value of this document apart from you trying to again confirm the same facts? No one raised doubts about, and even if we raised doubts, of the will that was expressed in written confirmations. Why did you make a new agreement? The legal nature of which is very controversial in this regard. I agree with you. I was choosing my wording very carefully. I would like to emphasize again that there were explanations from my mother only in writing. In the decision regarding me, they were not taken into account and they were not assessed. They were not mentioned. I didn't even know whether you assessed whether the PCAE and the HQCJ saw. Yes, we did see it. For some reason, was not mentioned in the written decision about me. And that's why, in order to additionally somehow to confirm that from my father, I chose this particular manner. Maybe in your opinion, it's not very appropriate. I did not say that. I said that the legal nature of this document is controversial. I agree with you. I'm very careful with my wording. I did not assess. I cannot debate with you. Why cannot you? Okay, thank you. Colleagues, do we have any other questions? Commission members have no questions. Maybe there are some additional questions from the PCAE members in view of their questions.
No? Mary, Jessica? Judge? No, thank you, Chair.
Дякую.
Thank you.
Ми завершили тоді.
And then we've completed our interview. And the Commission is giving you, Mr. Yuriy, an opportunity to address us up to 1 minute. Maybe you would like to describe something additional. Maybe you have not mentioned something. And maybe you would like to inform us of anything. Thank you so much for this opportunity. In fact, really, I wanted to inform important circumstances for public discussion, so to say, because that's a transparent broadcast, and I believe that they are important. In particular, I would like to emphasize the circumstances that, with respect to me, pursuant to results of the competition for the position of the member of the HQCJ, in which I took part in 2023, there is a positive decision of the selection commission with the participation of international experts, and Mr. Broekhuizen was also a member of that commission. And there is also a positive decision of the High Council of Justice that I, as the candidate for that position, complied with all the requirements regarding integrity, compliance with ethical norms, political neutrality, competence, etc. And as of the last year, there was a situation when, with respect to my candidacy, there were two contrary decisions. One on my compliance with the integrity criteria, and the other one on my failure to comply with this criteria. And that was one of the reasons why I challenged that decision with the court. Moreover, I would like to again express my gratitude to the members of the PCAE and HQCJ for thorough attention to my dossier, that you listened to me for the second time. I've tried to collect as many possible pieces of evidence. I've tried to provide arguments for my position, and I hope that I've managed to do that. Thank you for your work. Thank you. Thank you for your participation in the competition, and your interview is over. Thank you.
Шановні члени комісії та
Dear members of the HQCJ and PCAE,
спільне засідання комісії
the joint special meeting of the PCAE and HQCJ is announced as closed because we've exhausted